Yes, it's a good development because without doing something now, you can't just fold one hand and watch over this thing.
Sorry, Chinelo, if you can draw the chairman's attention to the fact that we're about to start. National anthem, please. Good morning, my lords, learned silks here present, my distinguished colleagues, gentlemen of the press. You are welcome to day 4 of the annual Criminal Law Review Conference presented by the Rule of Law Development Foundation. Distinguished ladies and gentlemen, you will agree with me that so far we have had an intellectually stimulating discussion on various aspects of our Nigerian criminal law jurisprudence. And by the grace of God, today will not be an exception. If you look at your program, today we are dealing with cutting-edge topics that go outside just the procedure, substantive law, and the evidence. After we have, or before we are prosecuted an economic crime, how do we manage the proceeds of crime? How far have we gone with judicial updates? Are there new cases? We discussed this last year. Are there new cases? Are there any new laws on the management of proceeds of crime? And to do justice to this, we have our panelists here. We have with us our chairman, who is no other person than Paul Harris Opole, Senior Advocate of Nigeria. Mr. Opole, Senior Advocate, is a managing partner in Suswam, Opole and Co. And for those of us who do not know, he had once worked as Deputy Commissioner with the EFCC for a while. Okay, commissioners. he has corrected me as a commissioner with the EFCC for several years. So he is an experienced person to steer the ship. Let us give him a round of applause. He will be navigating the waters. And we have with us someone who is not unfamiliar to the Rule of Law Foundation. In fact, LearnedSilk will consider you part of us. DC Ewolum, Senior Advocate of Nigeria, who is the principal partner of DC Ewolum and Co., all the way in Kaduna. Conferees, you observed that Mr. Ewolum has been with us for a while and has been making contributions. LearnedSilk today is where we hear from you yourself on this aspect of the topic. And I have seated next to him my very big brother, Olusegun Dalawo, Senior Advocate of Nigeria, a partner in Rikitafa and Co. LearnedSilk, you are very much welcome. I also understand that LearnedSilk Wole Agunbiade tried to make it, but he has sent his paper. I'm not sure whether he has a representative that will speak to the paper, but we as the foundation have the paper, and maybe in the course of the session we will have it. As again, the EFCC have decided not to come. We extended them an invitation to be participants, and they don't come. If you are friends with those in the EFCC, please, we try to balance the discussion, but they are not here. So I hand it over to the chairman. The time frame is stated there, and you can be liberal since we have availability of slot. Mr. Chairman, let's give them a round.
Gentlemen, thank you very much. I'd like to especially acknowledge my Lord in our midst. I would say he only just stepped aside from the Court of Appeal recently. So he's pretty much with us in practice. And there's so much we would still learn from yes, please. So, my Lord, you're most welcome. I'd like to, thank you very much. Without much ado, but I'd like to first of all begin by expressing my profound appreciation and gratitude to Chief J.B. Dowd, SAN, the founder of this foundation. Chief Daudu has done so much in the legal profession. He has done so much for the legal profession. And in his own little way, he's more like giving back to the legal profession and giving back to society. This clearly is what an NGO should be like. Chief J.B. Daudu, SAN, he's not here physically with us, but I believe he's online. I'd like to say we truly, truly appreciate you. My fellow conferees here, I thank you so very much for coming. And I'd like to say I feel highly honored that I have the privilege of chairing this session today. A session that is enamored by very, very eminent personnel, juggernauts in the legal profession, highly knowledgeable in the field, and we would all learn so much from you here today. I do not know if it's by coincidence or design, one way or the other, three of us who were privileged to have been called the same year are together today. Called to the Inaba, are together here before you today. Chief Ewolum himself, he was called on the same day as I, and so also Jalao. So all three of us. So I think your choice, Paul, I do not know, but somehow you got it right. Anyway, we have two speakers today, like had been said, and the topic we know, going by our program, is judicial updates and legislative developments in criminal law, criminal policy, and evidence, economic crimes, management of the proceeds of crime. Any progress? We have the lead speaker, who is ECN Wellum, SAN. We have 20 minutes for him to discuss the subject matter, but I'm again enjoined to be liberal because the third speaker is not going to be, he's not here with us, so we may eat into his time. And after him would be Jalao SN, and we'll have an interactive section after that, whereby we'll all speak, ask questions, and discuss and learn from one another on the matter. Now, globally, economic crimes are major concerns for developing nations, and curbing economic crime requires the actual investigation, the act of curbing the crime and preventing the crime. But oftentimes, there are proceeds of crime that come out of the crime as committed, economic crimes as committed. And a major question that is usually asked is, how are the proceeds of this crime managed? Economic crime in this sphere in Nigeria is fairly new. I mean, fairly new. The dimension is fairly new. Although it has always existed in codes, the penal code and the criminal code. But with evolution and the sophistication, it has continued to expand and take shape. So, what laws do we have today that will shape management of economic crimes? These are some of the areas that our lead speaker would largely and robustly speak to. Before I hand the mic over to him, I've read quite a bit of his presentation, but I wouldn't let the cat out of the bag yet. But I'll just say something which reminds me of, we can draw a link or inference with economic crime, proceeds of economic crime, and what have you. There's this story about an African leader who, upon taking power, coming into power, I think by military coup or something, he claimed all his predecessors were corrupt. And so they had stolen the monies of his country and taken them to some bank abroad, like say Swiss Bank or any of the banks. And when this happened, when he got into power, he threatened to put everybody in jail, all the criminals, all the former presidents in jail. And then he said, I'll go one step further, where the proceeds of our country, the proceeds of this crime are. So he said, they're in a foreign bank abroad. And then he left the shores of his country to this foreign bank abroad. And then there reminded them that monies, politicians, heads of states or presidents in this country, and they have traced them to the banks in this foreign country in the Western world. And then he said, I want all the monies repatriated back to my country so that we can use them for the development of my country. And they said to him, sorry, Your Excellency, no, sir, we can't do this. It is against our principles. It is against our banking code. There is banker customer confidentiality. So we will not release this information. Again and again, he threatened fire and brimstone, that he needed the information of all the currencies, all the foreign accounts, all the monies of his country. He needed them, and that he wanted them repatriated. Now, this is a clear case of proceeds of crime. He insisted and insisted, and the bank on the other hand, also insisted that they were not going to release or divulge any information. Then he sat back and said, yes, you are really the bank to deal with. I'm the next president. I can deal with you. So, it's a classical case of process of crime. How are they managed? But I'm sure the lead speaker will speak sufficiently to this scope, the laws we have, and the judgments that we have related to that, and what way forward. Unfortunately, we don't have the EFCC here now, but I do believe that one way or the other, maybe communique or papers from here would also reach them, and they would also learn a thing or two, and all for the good of our nation. So without much ado, I would now call on our lead speaker, who is no other than our own EC Enwelum SAN. Can we give him a round of applause, please? You have 20 minutes plus.
Mr. Chairman, my Lord, Justice Regular, JCA retired, Leonard Senior Advocates here present, Mr. Paul Dowd, whom I will call the DG, Rule of Law Foundation, my learned colleagues and friends here. I want to start by thanking the coordinator of the Rule of Law Development Foundation, Mr. JB Dowd SAN, who is a boss to me and also a bosom friend. During the day, he is my boss, but in the evening, he is my friend. And all the organizers of this conference for inviting me to this conference. Mr. Chairman, I think I'm a little bit familiar with the topic we have been given, having done many of the cases involving limited funds. I was a member of the federal government team set up in 2002 for the recovery of what is popularly known as Abacha loans. And we fought that case between 2002 in Nigeria here. Outside Nigeria, there were also foreign lawyers for either side, until 2014, when I got a judgment in the Supreme Court that said go back and continue prosecution. And when we went back and resumed the prosecution at High Court 27 FCT High Court, they now came for approached the federal government for resolution of the matter amicably. That was how this worldwide settlement was reached between the federal government and the Abacha family. It was part of the initial meetings, and they had to go outside the country because we had foreign lawyers who stopped there. So most of these repatriations had so far emanate from that worldwide settlement reached in the family. That is a matter of introduction. Now back to the topic. The topic for this session is judicial updates and legislative developments, economic crimes, management of proceeds of crime, any progress. It asks us to look at the latest judicial pronouncements and legislative developments on the management of the proceeds of crime, and in the process determine whether any progress has been made in the past 12 months. And let us start by looking at the legislative instruments for fighting economic crimes in Nigeria. We listed all of them, and we also went ahead to list the agencies established to fight economic crime or corruption. Now, confiscation and management of proceeds of crime. Under various statutes to fight and manage economic crimes, provisions were made for the seizure of assets and properties considered to have been acquired from the commission of economic crime. Examples are: A. Under the Corrupt Practices and Other Related Offences Act, at Section 37, the ICPC is authorized to seize any property reasonably suspected in the course of investigation to have been acquired in the commission of an offense. Furthermore, under Section 45, the Commission is also authorized to seize any movable property, including any monetary instrument or any accretion which is a subject of any investigation under the Act, when such is in the possession, custody, control of a bank or financial institution. D. Under the EFCC Act, at sections 21, 22, 24, 25, and 26, the Commission is also empowered to have any property of a person convicted of an offense under the Act and shown to be derived or acquired from such economic and financial crime and already subject of an interim order to be forfeited. C. Under the Recovery of Public Property Special Provisions Act, the Federal High Court under Section 8 shall make an order prohibiting disposition of property, movable or immovable, by or on behalf of persons being investigated, and whether or not the property is owned or held by that person or by any other person on his behalf. T. Under the Advance Fee Fraud and Other Fraud-Related Offences Act, Section 14 thereof, where at any stage of trial the High Court is satisfied that the prima facie case has been made out against a person, the High Court may, by an order and for such time as it may direct, prohibit the disposition of the property, movable or immovable, by or on behalf of the person under investigation or trial, by an order addressed to the manager of the bank or to the head office of the bank where the person has an account or is believed to have an account, directing the stoppage of all outward payments, operations, or transactions for the time being specified in the order, and to supply any information and produce books and documents in respect of the account of that person. E. The National Drug Law Enforcement Agency under this law, the National Drug Law Enforcement Agency Act, under this law, at Section 27, any person convicted of an offense shall forfeit to the federal government all the assets and property which may or are the subject of interim order of the Federal High Court after an attachment by the agency. And in Section 28, it makes it absolute that any property earlier attached under interim order of the court shall be forfeited to the federal government. I want to emphasize that in all these, the forfeiture or seizure must be by an order of the court. We'll come later to see whether in cases where these agencies do not get an order and go on to freeze, whether they are right or wrong. We'll come to that later. Then I gave an example of application of these laws with a case decided, and that is in Federal Republic of Nigeria against Dr. Mrs. Cecilia Ibu. That is the Federal High Court in Lagos. And we stated that the trial court ordered the forfeiture of the property of the accused person, numbering 94 properties from Lagos to Abuja to Asaba to Port Harcourt and to Dubai in United Arab Emirates. And it also ordered the forfeiture of various numbers of shares in 199 companies. There are many other cases of forfeiture of assets where forfeiture of assets has been granted, but our attention today is on the management of these assets and properties forfeited, whether permanent or interim, by the various agencies saddled with that responsibility. Now, management of the process of crime in Nigeria has been embroiled in controversy in the following areas. 1. There is controversy as to procedure of forfeiture or seizure and the issue of fair hearing. Last year, I want to take us back a little bit. Last year, we discussed this question of interim forfeiture and ex parte order, and we used two cases as example. The cases of then Patience Idifaka Jonathan against Federal Republic of Nigeria. It's reported in 2019, 10 Nigerian Weekly Law Reports at 1681 at page 553. The second case is that of Joy Obiageli Oti against EFCC and one other, reported in 2020, 14 Nigerian Weekly Law Report, part 1743, page 48. I am using these two cases, which we discussed last year, as a case study of the controversies that have arisen in one, the procedure for in the first place of seizure of these properties, and two, in the management of these properties. Now, if we recall, the case of Ibifaka Jonathan decided by the Supreme Court, particularly the judgment of Justice Sakas, the main thrust of that judgment as far as interim forfeiture order is concerned is this. He said, forfeiture is constitutionally permissible because the property subject to forfeiture was the evil sought to be remedied. Therefore, consideration is not given to the innocence of the owner of the property. That's because the contention then is that the way and manner the forfeiture is being had, it offends Section 44, which is the right of every Nigerian to own and acquire property in part of Nigeria. And when any of these agencies goes behind the individual concerned, if he sees his property and manage it, then it becomes a contentious matter in the light of Section 44 of the 1999 Constitution. And this is what the Supreme Court held, that number one, forfeiture, civil forfeiture is constitutional, and the right of fair hearing does not arise. Two, this is because the property is the evil targeted at, and not whether the person concerned is innocent or otherwise of the offense is being suspected or alleged against. And we went on to examine this reasoning of the Supreme Court. And we said that the contention over the years has been how to satisfy the court, because the condition is when we are applying for interim order, you must satisfy the court that is a prima facie case against the person whose property he wants to attach or forfeit in the interim. And we said the contention over the years has been the meaning of, quote, satisfy the court that there is a prima facie evidence that the property concerned is liable to forfeiture. And we contended that the test should be an objective test. In its ordinary meaning, prima facie evidence simply means credible evidence. However, the same Supreme Court, in this case of Agui against Ogbe, 2006, 7 MJSC, page 1 at page 23, held that a prima facie case should mean evidence worthy of belief, and for evidence to be worthy of belief and credible, it must not only proceed from a credible source, it must be credible in itself, in the sense that it should be natural, reasonable, and probable in view of the entire circumstance. In other words, for there to be a prima facie case on which the court should act to make an order of forfeiture, that the evidence must be credible, and for it to be credible, it must proceed from a credible source. It must be credible in itself, in the sense that it should be natural, reasonable, and probable in view of the circumstance. Now, when the court said that the only condition for grant of interim order is that, one, the prosecuting agencies have suspected a particular individual, or he is under investigation, that it is enough to apply. If you now apply the judgment, the reasoning of the same court in this Agui against Ogbe, you now discover that they have raised questions around their earlier judgment of the meaning of prima facie case. We went on to also state that now, as to the controversies that have arisen in the management of these seized, or rather forfeited assets, we said the agencies concerned, what they do is simply, first of all, as soon as they get that interim forfeiture, they seal the property up. they engage property managers to care for them. And even in cases where they are managed by estate agents and the owner succeeds in proving ownership, incomes received during the interim order from the property, example rent, are never handed over to the owner. 2, we also said once a property is marked EFCC, for instance, keep off by the EFCC, that property is left to lie fallow for a good number of years. These agencies simply seize assets and properties arbitrarily, rush to courts to obtain interim order of forfeiture. The owner of the assets or property, who may be suspect, is now made to file a case to challenge the interim order at his expense of time and resources. In the event he succeeds, the property has lost value due to poor handling and lack of maintenance, and instances of these abound. Now, these concerns raised demand more circumspection and review of the reasoning in the 2 cases we cited. Having identified the controversies relating to the assets, the procedures, first of all, in getting the forfeiture order, and secondly, in the management, we went on. We said, management of proceeds of crime in Nigeria has been embroiled in controversies which we have dealt with. It has been difficult to say with certainty over the years, and the records are not there in the public domain, that what has been recovered, how effective is the management of these properties assets. I'm not too sure any of us here can say with certainty have all the assets recovered in the last, let's say, 6 years under this regime. We have a list of all the assets, and they are in public domain, whether monetary instruments or properties. That is very doubtful. This had led to public outcry for a separate agency to be saddled with confiscation, forfeiture, and management of property derived from unlawful activities. Now, asset recovery has 2 levels. The first level is to identify, trace, freeze, and confiscate. The second level is to manage the proceeds according to acceptable laid-down procedure and the law. It is thus important to establish the legal framework for managing and utilizing the assets or properties of forfeited for development purposes. And we looked at the legislative development in the management of these assets. The first attempt at establishing a management agency was the Proceeds of Crime Bill, which was sponsored in 2016 by one Honorable Kayode Oladele. It passed through the legislative process. Essentially, the bill set out to establish the Proceeds of Crime Recovery and Management Agency. That's setting up now an agency saddled with management of all the proceeds of crime. And he said that the agency shall have power to implement and enforce and administer the provisions of the bill. And the objectives of the bill were: 1, to provide for an effective legal and institutional framework for the recovery and management of the proceeds of crime or benefits derived from unlawful activities. 2, to deprive a person of the proceeds of unlawful activity, instrumentality of an offense, and any other benefit derived from an offense committed within or outside Nigeria. 3, to prevent the reinvestment of unlawful activities in furtherance of criminal enterprise. 4, to harmonize and consolidate the existing legislative provisions on the recovery of profits of crime. 5, to make comprehensive provisions for the restraint, seizure, confiscation, and forfeiture of property derived from unlawful activities and any instrumentalities used or intended to be used in the commission of such unlawful activities. The bill went through the National Assembly and was passed. After the passage of the bill, it was transmitted to the executive but was not signed into law. However, the Federal Executive Council on October 6, 2020, that was sometime last year, sent its own executive bill titled also Proceeds of Crime Bill, with a covering letter read during the plenary session by the Senate President for passage into law. In the letter, Mr. President drew the attention of the Senate that the to the fact that the earlier proceeds of crime bill passed by the National Assembly 2019 was not granted assent due to some issues that were identified during review. He therefore urged the National Assembly to pass the bill submitted in 2020 by the executive. Now, the new bill presented by the executive before the National Assembly has the following objectives. A. Enforcement and administration of the provisions of the bill and the coordination of the recovery and management of the proceeds and instrumentalities of unlawful activities in Nigeria in collaboration with anti-corruption and other law enforcement agencies. Let us look at this A. Let us look at this A, which is coordination of the recovery and management. If you go to in the earlier part of this paper, so many agencies, NDLA, ICPC, EFCC, customs, and so on, they were given powers to freeze assets and to keep. These apart from the orders to be made by the High Court. Each of them now manages what has been seized, what has been recovered, monies in the banks that are frozen, independent of the other. So, A here intended for all of these to be coordinated by one single agency. Of course, they will now be in bold or in possession of all these, but with coordination of the relevant agencies. Meaning, each agency, as they get forfeiture, they relates with the intended agency for management and hand over same to them. B, most importantly, the agency created or to be created will ensure that Nigerians can benefit from the proceeds of crimes by ensuring that once recovery is made, the properties and assets will be secured and that the financial forfeitures granted through a High Court order can be paid into what is to be created at Central Bank now, called the confiscated and forfeited account, to be domiciled in the Central Bank. Now, the bill has not yet been passed by the National Assembly. It is instructive, therefore, that effort is being made through legislation to better manage the process of crime. Various agencies today handle forfeited assets in their independent manner. There is no coordination in the management of forfeited assets in Nigeria. And we will recall instances where some people will go to courts and say, this is what has happened with my property. And it takes 1, 2, 3 years to even resolve whether that property actually has been forfeited or otherwise. There are cases where some of these agents will say, we don't know about that property. We are not the ones that froze it. And so on. So there's still controversy in the management of the process of crime. Now on judicial updates, I will again take us back because there's not much judicial updates on the management of process of crime, except the case of Federal Republic of Nigeria against Chief Mike Ozokreme, SAN. But in dealing with the case of Federal Republic of Nigeria against Chief Mike Ozokreme, we also went back to touch on the case of Mrs. Patience Ibifaka Jonathan against Federal Republic of Nigeria and the case of Joy Obiagelioti against EFCC, to look at both of them to see whether any progress has been made in the latter case, the managed in the order for forfeiture, and how properties have been managed. First of all, Patience Ibifaka Jonathan against Federal Republic of Nigeria. The issue was interim forfeiture of an account that was traced to the subject, and they went to court. That was the one Justice Akas now said, no. Well, Supreme Court said, no. Look, the target is the property in question. It has nothing to do with the enforcement of fundamental rights. And in any case, Section 44 of the 1999 Constitution has a proviso. And under that proviso, there is nothing wrong with interim forfeiture. He even went back to certain cases decided in England. Let me refer to those two cases for our better understanding. Yes, The case of Butler against United Kingdom, decided in December number 41661/98, which interpreted the Proceeds of Crime Act, which is called BOCA in England, 2002. He further relied on United States cases of United States against Usury, 95 to 9345 518 US 267, and the case of Bennings against Michigan, 94, and all that, to the effect that interim forfeiture proceedings are separable from the innocence or otherwise of the accused persons. So, that is the reasoning which was adopted by our own Supreme Court here, on the basis of which they gave judgment. That judgment of the Patience Ibifaka Jonathan was adopted by the Court of Appeal, Lagos Division, in the case of Joy Obiagelioti against the EFCC, which I have mentioned earlier on. And I said, Justice Akia, I hope I'm pronouncing the law very well, otherwise I plead guilty, stated that the Supreme Court held in then patient John Ibifaka Jonathan that forfeiture is constitutionally permissible, even in the case of joint owner of property, because the property is a subject of forfeiture, and the property was the evil sought to be remedied. Therefore, consideration of the innocence of the owner is not applicable. Now, in the case of Federal Republic of Nigeria against Chief Michael Zokome, that was the case of a colleague. I think all of us here may have heard, even if you don't know, he was representing the former governor of the state, Ayo Fayoshi, and the EFCC had closed several accounts of the former governor, but I think one of the accounts was not frozen, and he paid the lawyer, Chief Michael Zokome, 75 million as professional fees, and EFCC quickly moved in and froze it. Well, they got interim order of forfeiture from a court. He got that order set aside and went on to operate that account. EFCC went to another court, and the court now granted an order that it should be frozen. When it got to the Court of Appeal, the main reasoning of the Court of Appeal is this. This is what the Court of Appeal stated. The rule of forfeiture is an example of a wider principle that a person cannot benefit from his own unlawful activity as a principle of public policy, not a principle of justice, to produce a fair result in all cases. I will read that again for our better understanding. The rule of forfeiture is an example of a wider principle that a person cannot benefit from his own unlawful activity as a principle of public policy. In other words, it's a principle of public policy, not a principle of justice, to produce a fair result in all cases. And he went on to say, it has to be so, because the rule was devised to resolve the necessities of particular cases and had to develop more forcefully without a great deal of consideration, either of its scope or of its exceptions or of its fundamental underlying rationale, resulting in controversy as to its scope, uncertainty about its exceptions, and confusion as to its rationale. The application of the rule thus depends on circumstances of each case without losing its bearing or focus on unlawful activity or criminal acts. It is sought to remedy under the banner of public policy, not a rule of justice. The case now went on to determine the applicability of Section 25 of the Money Laundering Prohibition Act 2011, under which that money was seized, vis-a-vis Section 192 of the Evidence Act, and therefore concluded that legal practitioners are excluded from the definition of quote and unquote designated non-financial institutions as contained in the Money Laundering Prohibition Act 2011. It held that Section 25 of the Money Laundering Prohibition Act is inconsistent with Section 192 of the Evidence Act and therefore cannot override or amend the Evidence Act. The Money Laundering Act Prohibition Act 2011, as far as it applies to legal practitioners, is invalid, null, and void. The court went on to state that it is not a requirement of the law that a legal practitioner will go into inquiry before receiving fees from his clients to find out the source of the fund from which he will be paid. I only want to say on this case two things. One, the issue of lack of fair hearing, which was upheld because civil forfeiture is not a rule of fair justice, but rather issue of public policy. And that was why it was being, that is what the court said, relying on foreign authorities. And then further ahead, it was constitutional. Here, in the case of Michael Sokolo, apart from the fact that, well, the main thrust of this judgment is that legal practitioners are not under the Money Laundering Prohibition Act 2011. They are not covered by it, and Section 25 of that law is against Section 192 of the Evidence Act. Therefore, legal practitioners are free. Once your client says, come and take your money, go and take your money and go. You don't need to go behind. You need to find out, did my client steal this money from Mr. X or Mr. B or Mr. C? But more importantly, that issue of civil forfeiture and otherwise, the Court of Appeal took a slightly divergent view of it and held that where such properties are seized, the owner still has a right on production of evidence and documents to establish ownership, to apply to court to have it set aside, which is contrary to what was done in the case of Joy Uti against the FCC. Mr. Chairman, I know my time is over since you have been looking at me and then looking at Paul, the DG. So, like I said at the beginning of my paper, I am here to share, to learn, and to grow. I know others have also various views to present on this. If I have succeeded in stimulating healthy debate on this, I will have done my job as a representative. Thank you very much, and good morning.
Thank you very much, my brother Silk. Well, you've done justice to your paper, and we have come out more informed about the position of the law and the current developments regarding management of proceeds of crime in Nigeria. Before I yield the floor to conferees for their comments, questions, contributions on the paper, and I'm sure my brother Silk is still here to answer to questions that may arise. I'll just have one or two comments to make concerning the paper. First, it is a beautifully, prepared, well-researched, and well-presented paper, and I commend my brother for a great job. He's very ably experienced in management of proceeds of crime or corruption, anti-corruption related cases, nationally and globally. So I'd like for us once more to give him a round of applause for the presentation. Well, there are one or two things I'd like to talk about flowing from the paper. You talked about the powers of the Companies and Allied Matters provided by the Companies and Allied Matters Act for CAC. Powers such as arraignment of persons and incorporated trustees and businesses pursuant to Section 8 sub 1 of the, that they can arraign, investigate fraud-related cases as per powers under the CAC Act. I don't know, are there quite one or two celebrated cases or known cases that we would say that the CAC has exercised their powers as provided by law. You may want to guide us or inform us if they have taken advantage of that law. For SEC, Securities and Exchange Commission, a case that may come to mind is that of, if I recall vividly, Mr. Guarzo. I think his case came up, the internal affairs of Securities and Exchange Commission, and it was contended that he had infringed the law, and which led to him being prosecuted. And I think currently the judgment, he's been acquitted, I think, on the appellate court, if I'm right. Okay, he's been acquitted. So probably I think maybe we could talk a little bit about that. And sometimes one may want to ask, let's look at page 230 of your presentation, particularly D, where you talked about advance fee frauds and other related offenses, particularly section 14, where that at any stage of a trial, a high court is satisfied that the prima facie case has been made out against a person. The high court may, by an order for such time as it may direct, prohibit the disposition of the property, movable or immovable, by or on behalf of the person under investigation or trial, by an order addressed to the manager of the bank, on and on and on and on. This order, is it an interim order or is it a final order? I would hope that you would, clear the air on that. One other area I'd like to look at is now on the issue of management of the proceeds of crime. A common query that a keen observer would raise is one which you properly and aptly addressed. We know that agencies like the customs, the police, NDLEA, EFCC, ICPC, and such other agencies, prosecutorial agencies, investigative and prosecutorial agencies as such, they are not specifically trained or equipped to manage proceeds of crime in terms of management of assets as well as management of funds. Like I said, you properly captured it. A common scenario is, let's look at a classical case. If you recall the case of Mude, there was this Mude guy, gentleman who was said to have, he was already convicted. It had to do with a Brazilian bank, sale of an airport, and then, crippling and crumbling of a bank in Brazil, and on and on. EFCC did a great job and investigated the matter. He was convicted, and proceeds of crime. He had a lot of properties across Abuja, Lagos, and I think somewhere in the east, as well as other places. Now, these properties were forfeited. If you recall, there's a building they used to call Russell Center in Wuse, some part of Wuse. I don't know what name it is now. That building used to be one of the buildings that was forfeited. It was a state-of-the-art building at that time. But it was left to EFCC to manage. It was left to them. I think what happened was probably they got somebody to manage it. But at the end of the day, between that time and now, if you see the state of the property, it's a sorry state. You may want to cite also the example of Chelsea Hotel, the original Chelsea Hotel in central area. That had to do with, I think, Bayelsa case, Alamasia, and Lamasia's case. Now that also ran down because they were not properly equipped to manage it. So what happens? These are economic assets. If they are forfeited to federal government or to whoever it ought to get to, then the question is, how well are they managed so that the value does not depreciate? I'm glad you spoke pretty well about that. So it is something we must critically look at and look for ways in which that can be improved. And that underscores the need for us to have an agency like the Management of Assets Agency as proposed. It's unfortunate that it has tarried and delayed for this long. But I hope sooner than later we would have that act, and that the assets that are continually forfeited can properly be managed by competent agencies or organizations. Imagine a situation whereby an airplane, for instance, is forfeited and, probably abandoned to rot, because I do not know how many pilots there are in the EFCC or in the ICPC or in the police. Thank God the lead speaker reminds of our Albarca Air. Some of you who are fairly older would know. My Lord would know. You know Albarca Air. When Albarca Air was flying, they are all littered at the airport there. And then there are, multiply effects of these things. The economy, unemployment, maybe loans. So these are things that I think government need to urgently look at, so that as you are working and fighting corruption, fighting economic crimes, the proceeds, the result of your labor is well managed, so that it also works well for the entire economy. Otherwise, you'll find ourselves just doing, one step forward, and then the same progress that you have made will be lost in the entire circle. The learned speaker, my brother Silk, spoke pretty well. He captured the essence of the case of Ozekome, Mike Ozekome, FRN and Ozekome, as well as that of Patience Goodluck and FRN. And I think I will not reinvent the wheel. I'd like that we, after here, take our times to properly read these two cases. They are very, very important on this subject. And so, having said this is just like a recap of what my brother has said. I'd like to call on panelists, the conferees, to please feel free to ask your questions. I think we'll take yours before we take yours, right? Oh, really? Okay. Well, please don't forget the questions that you have. Take note. I've also done a fair recap. So, and your comments, please take note, because I'm going to call on all of you here and the gentlemen on that side. And I'm sure we'll take some other people online. So, we'll do the whole thing holistically. So, at this point in time, call on, yet again, my brother Silk, Shagun Jalao, SAN. He will be speaking. Ordinarily, he has 10 minutes to speak. We've had the lead presentation. He has 10 minutes, but I'll say it's 10 minutes plus. Thank you very much.
Honorable Chairman, my lords, my brothers Silk, my colleagues, I am indeed honored to be standing here today as part of this great august occasion. Unfortunately, I find myself in the dilemma that is usually faced by discussants after the lead speaker has spoken, because the lead speaker has touched on practically everything of note or worthy of note with respect to the topic before us today. However, I'll contribute my 2 pence. No, I will try to avoid repeating what he has said already. The paper itself talks about the management of proceeds of crime and whether there has been any progress. Learned Chief Speaker has gone very detailed into legislation, into the cases. But my concern is actually the management itself of these assets with respect to interim and final forfeiture. Because that's actually where the problem is. Yes, there is a paucity of laws. Yes, there's a paucity of judicial authorities. But what there is actually addresses forfeiture, both interim and final. What there is actually addresses what should be done with respect to the procedure for forfeiture itself. But there is a serious lacuna with respect to management of these assets. One doesn't have to be a lawyer, with all due respect, to see that there is a serious problem with respect to management. A layman will tell you that there are various premises all over that we can all see in our day-to-day lives that are marked EFCC. There are properties that we know are in ICPC, thank you. There are premises that we know where movable assets, for instance vehicles, are kept. And we have all seen for years these same vehicles are there rusting and rotting away, depreciating in value every day. The question arises, shouldn't there be something put in place to ensure that if these properties can be used, some use is made of them pending when these cases are determined? This is especially true with respect to landed property. Let me just give you a small anecdote. One of these banks briefed us recently to recover some monies from a debtor. They gave us the terms of the contract between them and all that. We went to the addresses where these people were to be served, the company. At each instance, every address that was given, we were given 3 addresses. When we got to those addresses, we found out that those addresses were occupied by EFCC. 3 different addresses in this city. Same client. They would just write EFCC there. We made inquiries. What is happening here? Where are the people there? What they tell us is that property is taken over by EFCC. Nothing is happening there. It's just there. Some officers are outside. In some instances, you can enter, the officers are inside, nothing is happening. Now, all this is obvious to the common man, even without all these landmark cases that we know the situation is the same. So the issue is, why hasn't the legislation, which has been mooted since 2015, been passed into law up till this instance? We first heard of it in 2015. It revived in 2020. But up till now, nothing has happened. With due respect to the legislature, when there are issues which concern them personally, before you know what's up, it's passed into law. First reading, second reading. Before you know what's happening, the act is there, ready to be enforced, because it concerns them. But we have a situation here whereby a process of crime bill has been in the works since 6-7 years going now, and nothing has happened. It has not been passed into law. We don't want to say it's a case of, like EFCC will say, they are not here, corruption fighting back, with all due respect. But there is a need that these things are followed up properly. This is what our legislators are there for. If there is no proper foundation, the courts cannot go beyond what is already in law. The courts can only do judicial advocacy if there is a foundation for them to move from. If there is no basic law with respect to the management of these assets, there is little or more the courts can do. The recent cases abound. The recent one was of this FRN against Maynard, where judgment was given recently. All the court said was that these assets be forfeited. Now, these assets, some of them have been under the control of the EFCC for about 3 years. There are cases I'm aware are found in court whereby this order of forfeiture has been challenged. Now there's a judgment separate from those cases, saying that those items, those properties are finally forfeited to the government. But what has happened in this intervening period? Some of those properties are commercial properties. Nothing of note has been happening with respect to them. Like we have observed from what the learned chief speaker said, they keep on depreciating in value steadily. So that at the end of the day, for instance, let's take cases where innocence is proved at the end of the day. What remedy is left for the owners of those properties? Because they have to be given back to them. What are they going to do? Where do they have recourse? What recourse do they have? Their properties have completely depreciated in value. Nothing can be done with them anymore in many instances. The example of the Pepsi Mall, that's what it's called now, Pepsi Mall. The example of the Pepsi Mall was given earlier. I was the general counsel when those cases were going on. Onwode and FRN and Onwode. I was the general counsel representing. But the fact is that even now, the Onwode himself, I'm aware, have instituted cases against the EFCC and some other people with respect to how the properties were managed, how they were taken over and managed during the subsistence of the charges. Now, there is a lot of controversy. He has alleged that he was cheated, that there were underhand dealings involving the officers of the EFCC, involving some of the lawyers involved. Now, if there was legislation which specifies exactly how these things are to be managed, gives a step-by-step direction as to what is to be done, issues like this would not arise. And if they did arise, they will be dealt with because the legislation is there to say what steps should be taken. So I think our focus here today, with all due respect, should be with respect to legislation. I think a pressure group of some sort, maybe arising from here, should be directed towards the legislature to ensure that something is done urgently, because everybody suffers for this. There are instances, like the speaker said, there's a multiplier effect on the economy. When you see a property that's commercially viable, that has been invested in by whoever it is, and then, for instance, it has been taken over by tenants who have businesses going on, ongoing, and all of a sudden, it's sealed up, nothing can be done with it anymore, and it steadily depreciates in value for years until judgment. And then after judgment, everybody's faced with the dilemma of what happens. Where do we go from here? So, with all due respect, my thought, my take, is that we should focus on legislature and ask them to do the needful. There's a need for that. Once that is done, my belief is that everything will fall into place and we'll make progress with respect to management of proceeds of crime. I am not sure I've used up my time. Yes. Yes, that is. With all due respect, I wish to conclude by thanking everyone here for the opportunity to be part of this. I hope that we won't stop here, like I said. We need to make progress, move to the legislature, and ensure that they take the steps they need to take. Thank you very much.
That was an excellent presentation by Julao SN. The man himself has been in the theater of a lot of these cases, anti-corruption related cases he's been involved in. So I'd like to thank the organizers for actually getting probably amongst the best lawyers, I mean, let me not say best, maybe most active lawyers in cases relating to corruption, anti-corruption in our country. Julao is very, very active in that regard. So also is when I commend your industry. Now, before we go on to take questions, I'd like to just do a brief maybe adumbration like he has done, just a recap of his presentation. I think it was succinctly, it captured the entire presentation, the paper, and one thing that comes to mind is it appears that originally our focus on actions bordering on legislative updates fairly restricted us to the past 12 months. But I think that we need to be able to achieve much, we need to go beyond the past 12 months, maybe in the last 6 years or more, or 10. But sadly, not much has happened, even in the past 6 years or 10 years or 1 year. So there's a need for us, for legislators, to very seriously and urgently take steps in this regard. But again, you may say you can't lay the buck on the legislature, because they would remind you that they once had passed a bill and it was taken to the executive for assent. And rather than assent, there's another bill that came, an executive bill that came only recently, which is again to be considered. Of course, the president has the prerogative, and from the communication from what we read from our erudite presenter, the president had reasons, and well, I'd like to pause here for a minute so that we can take everything together. Our brother Silk Wale Ogumbiade SAN, who is unavoidably absent, had sent in his paper, and I'm sure it has been circulated. We all have it, right? Are we together? Okay. It will be circulated. Yeah, there are enough copies, and then in the course of the program, I'm sure, whoever doesn't have would have. So he has asked that our brother Paul, the DG of the Rule of Law Development Foundation, should do a presentation, an abridged presentation on his behalf. So I'll yield the floor to Paul J.B. Daudu.
Thank you very much, Mr. Chairman. As I really apologize. As the session was going on, Leonard Silk sent me a message that I should please apologize on his behalf. He's held up in Kaduna, and he would have loved to be here with us, but he has circulated the paper, and I'm sure will make it available to you. And he starts by highlighting that he's aware he had 10 minutes, and Mr. Chairman, I will definitely try to do it in less than that. He started in his introduction by saying that I believe we have come to know in the course of this conference that proceeds of crime is a term given to money or assets gained by criminals during the course of their criminal activity. And Leonard Silk relied on the Crown Prosecution Service UK as a source for that definition. And Leonard Silk went by way of comparative analysis. He talked about the UK Proceeds of Crime Bill, which has now become the UK Proceeds of Crime Act 2002, which established an asset recovery agency, which later became part of the Serious Organized Crime Agency. So you can see the approach by Leonard Silk is to go to other jurisdictions for best practices. And he said in the UK, forfeited assets and proceeds of crime, which is similar to what all the speakers have been speaking about, are actively maintained, are managed to maintain their value when desirable. An application is made to the appropriate court for appointment of a management receiver. But he said that in Nigeria, the contrast appears to be the situation. and that we do not have any coherent system for the management of proceeds of crime. And he lamented about this, that despite the fact there was a proceeds of crime bill which was referred to by the lead presenter, it has not received presidential assent. Presumably, he feels, because of the complaints of some of the agencies, that the bill was intended to curtail their powers. He feels that there seems to be a power grab between the various agencies, and that may be affecting the reason why we do not have a unified system for management and of proceeds of crime. He also said that it was 1 year in October this year since a bill was sent to the National Assembly by President Muhammad Buhari, an executive bill. But yet, that same executive bill is yet to be passed. Meanwhile, federal government agencies, particularly FEC, have been receiving regular reports on the activities of an asset recovery management unit, which was established by the Ministry of Justice. And in October 2009, the AGF and the Ministry of Justice issued Asset Tracing, Recovery and Management Regulations 2009, which he supplied where it was gazetted. He said in essence that those regulations empower the AGF and the Ministry of Justice to take custody and manage all forfeited assets, collect data relating to those recovered assets within and outside Nigeria from all law enforcement agencies who empower them to undertake recoveries, maintain a depository for all forfeiture orders issued by the Nigerian courts and for such courts outside Nigeria, because courts outside Nigeria also give orders of forfeiture. So he pointed out that what we have guiding us are regulations from ministerial departments. And he asked this question: do the guidelines of ARMU, and then he also pointed out that the Presidential Advisory Committee of Against Corruption also issued its own guidelines. So we have two guidelines in place. The one issued by the Federal Ministry of Justice and the one issued by the Presidential Committee. And he asked this question: do the guidelines provide desirable legal framework for the management of proceeds of crime? And I think later we'll answer that question in the course of our discussion. He also pointed out that on October 25th, when Director Operations of EFCC appeared before a Senate committee to defend the budget, some members of the committee faulted the transfer of forfeited assets to the office of AGF by the EFCC. The EFCC had informed the committee that the assets have been transferred in line with the 2019 regulations for proper management. A member of the committee said, in his words, that the assets needed to be sold to raise money to finance the budget. Again, you see there's a gap. And he did not see management acumen in the AGF that was not available in the EFCC. Here again, we see a power tussle. Again, if we had rules or legislation on this, we wouldn't be arguing who has the acumen to do such things. Now that a bill is yet to be passed, the questions he asks are: has the impediment to the passage of the bill as a result of rivalry among various law enforcement agencies been dislodged? You all agree with me, it is not yet dislodged. Do we now have a centrally managed database of recovered assets? Do we have instances of misuse, loss and theft of recovered assets? In other words, relooting the loot. Recently, the federal government, through its interministerial committee on disposal of forfeited assets, chaired by the Solicitor General, began a screening of independent valuers who are expected to manage the sale of all forfeited assets. He gave us all this as his contribution and his food for thought, and once more apologizes for his absence. Thank you very much, Mr. Chair.
Thank you very much. It's been a very wonderful presentation by Wale Ogumbiade, SAN. Once more, can we do him a round of applause, please? Please, Paul, when you speak with him later, send him warm regards from the Rule of Law Development Foundation. And particularly this is our own panel. Well, anyway, we all heard the presentation. I think it was quite succinct and aptly captured the subject matter. So the trinity of the presentation by the three eminent speakers, covers the entire scope and gamut of the subject matter. I would like to say there isn't much more to say other than to just mention that the issue of this Presidential Advisory Committee Against Corruption, as well as the asset tracking, recovery, and management regulations, these two regulations in the Gazette, I do recall that sometime a few years back, under this current government, there was an instance where some persons were being prosecuted by these agents, by these bodies, or under these laws. I can't remember the parties in that case now, but if my memory is correct, I do remember the court saying that they did not have prosecutorial powers. Does anyone remember that case? No, Obla, I think Obla was the prosecutor in that case. Obonu Obla, not Obla SAN, but Obonu Obla Okoye-Ofem, yeah, there was this particular case, and I do recall, but I'm sure in the course of time I'll remember the name of. I know that there was an attempt to prosecute some persons using this law, and then that government, that body or arm of the Ministry of Justice, not Ministry of Justice proper, but they had commenced a prosecution, and the court said, look, hey, there's the Obla committee. That's right. Yeah, that's what I'm saying. Yes, so not God in Obla, SAN, Obono Obla, yes. But I don't remember the particular case now. But I do recall the court said no, he didn't have prosecutorial powers, and that this was not a law, so to say, under which you could say you were going to prosecute someone. So that comes to mind. So I think there are very potent questions asked that we would need answers to. Paul, I hope that you can answer some of those questions, which he himself asked, and I also trust that the lead speaker will give a robust approach to answering the questions or the posers, while inputs from all of us here. Questions such as, now that the bill is yet to be passed, the questions to ask are, has the impediment to the passage of the bill as a result of the rivalry among the various law enforcement agencies been dislodged? Do we now have a centrally managed database on recovered assets? Do we no longer have instances of misuse, loss, or theft of recovered assets, which are, like Paul would say, relooting the loot? Do these instances exist? And if they do exist, what can be done about them? So I think at this point in time, I'd like to yield the floor to conferees for questions, comments, and inputs in whatever form. So who takes the first bite? Somebody's raising her. Okay, yes, I can see you raising your hand. So you tell us your name and where you represent, the organization, and then we will hear your question. I think what we perhaps will do is that the speakers may have to just write down the questions as much as you can, so that when we take all of them, you will assure that they're answered across board. We won't be doing question and answer, so please take that. Sorry. Okay, there are some other gentlemen there. Let me even see. This chairman, they move around. Make I follow see. Okay. Yes. Okay, our friends are here. Gentlemen, how are you? Okay. All right, thank you very much. So, no, don't worry, we'll take questions from you. When we call you, you will just come forward, and then so that we all can see you, and I'm sure people online can follow. So, thank you very much. So, yes, the first question, please, can you...
Okay. Good morning, Chairman of Session, my lords here present, and the lead presenter. My name is Pius Yuzua. I'm from Federal High Court. I like to thank the lead presenter for his paper this morning. The angle that has caught my attention on this subject matter is the issue of snatching away proceeds of crime in foreign jurisdictions. You will pardon me if I'm overstretching your presentation, but I feel that when we are discussing proceeds, tracing of proceeds of crime, recovery of proceeds of crime, I think we should also look at what is happening now, what appears to be the order of the day. The domestic front, I can say, is becoming hot for those who want to loot and are looking elsewhere. And so, my question is, do we as a nation, or does the anti-corruption agencies of this country have the capacity to trace proceeds of crime, to recover proceeds of crime stashed away in foreign jurisdictions? Or do we have to rely occasionally on the likes of the Panama Papers or the WikiLeaks? Do we have the capacity to do that? What is the deliberate attempt on ground by this nation to trace some of these proceeds of crime stashed in foreign jurisdictions? Have we taken advantage of conventions like the United Nations Convention Against Transnational Crime? We have the United Nations Convention Against Corruption. All these conventions have taken into account with every seriousness the issue of transborder snatching of illicit funds in foreign countries. Thank you very much.
All right. Thank you very much. So you just pass it around like that, and then we'll take, while our speakers will take the names of the speakers as well as the conferees as well as the major notes. But I'd like for us to make it brief, because I'm sure we would like to have so many people ask questions. So let's make it brief so that we can go on and on and on. From the Federal High Court, you're most welcome, my brother.
Good morning, the chairman and the...
Incidentally, it's from my village, so...
Good morning, the chairman and the other eminent speakers. I want to stand on the existing protocol. My name is Sojourn Ubatombos. I'm from the Federal High Court too. And I want to make a little contribution. At the end of the contribution, I think my question will flow. I want to say, as it is presently, we don't have any act in place for management of proceeds of crime. What we have at best is a regulation. And in line with the principle of checks and balances, I want to say whether it is possible that the court, while granting forfeiture, especially final forfeiture, whether the court can go ahead to make order mandating either the prosecuting agency or the AGF to auction the forfeited properties by stipulating time frame within which this auction can be carried out, and if possible, ask that an affidavit of compliance be filed thereafter. I want to believe if this thing is done, I think it will put them on their toes to do the needful. If they are either going to comply or rush the passage of the act, I think the court too, I want to believe, will have to step in to rise to the occasion. And I believe this is done, I think it will help a great deal.
Thank you very much. That was very good. I'll continue to thank the Federal High Court for their powerful representation here. Somebody else asking a question from, are we done with this side? Would like to be democratic. Are you asking a question yourself? Okay, yes. Captured by the, you want to step forward? I want you to be captured by the purpose of the benefit of our online viewers. Okay, there she is.
Good morning. My name is Chinelo Bozo. First is a clarification. During the course of the session, a proposal was made that we try to stretch the topic of any consideration beyond 12 months. The idea of the conference is to give constant updates every 12 months. So at the median session, we considered beyond 12 months. But afterwards, we'll be doing 12 months, just updates. But that doesn't restrict any presenter from going beyond that time frame if it's deemed that it will enrich the conversation. But that observation is taken account of, and we will try to make sure that if there is anything that our 12-month limitation will stop us from benefiting from, we will do that. We will not allow that to happen. Then secondly is on the point that he raised. That point has been raised constantly in this conference. And the point is that this is an area where we expect judicial activism. Because indeed there is no provision of any law that says the court should order that the properties forfeited or money forfeited be handed over to the EFCC. The courts make that order without any law. So I do not believe that there is anything stopping the courts from ensuring that the EFCC is not in custody of the money or the prosecuting agencies, that tomorrow we are having issues with calculation. And we have also said it before, that heads of courts can also come in to say that when such orders are made, the chief registrar of the court is put on notice so that the courts have their own documents, they have their own registry of what has been forfeited so far by the courts, interim and final, so that when we are doing our checks and balances, the Federal High Court, for instance, can say this is the amount so far that has been forfeited to EFCC by the Federal High Court. This is the amount so far forfeited to the EFCC by the Federal High Court to the ICPC. And those records can now be put together and handed over to maybe the Attorney General of the Federation or any other authority. Thirdly is that is a personal opinion on the process of Crime Management Agency. I sincerely believe that it is just an avenue of creating multiplicity of agencies. I do not think that we need it. I believe that we can make amendments to the laws that have established prosecuting and law enforcement agencies, directing that they, within a time period, because if you look at that bill, you will find that there is no really time frame for them to submit to the agency that is supposed to be monitoring them. So somebody can recover and decide to sit on it for 5 years, 6 years. There is no punishment for failure to report or remit. So what you will have, especially you know how Nigerians are, EFCC will sit back and frustrate whatever effort that is being made, and then when you start crying foul, they will release 2 or 3 billion to you and sit back on the rest of the money. Then you will run from pillar to post looking for what EFCC has recovered or not recovered. But if we add, maybe if we must establish the agency, add it to the bill that if you recover, you are mandated under the law within 7 days, 24 hours to report to the management agency and transfer whatever you have recovered to that agency. I think that would be a step in the right direction. Thank you.
Thank you very much. We said 2 minutes. You exceeded 2 minutes by another. Well, we'll grant you that concession because of.
Mr. Chairman, I also have something.
Yes, please go ahead.
Yes. So, good morning, Mr. Chairman. I will just make my question and slash comments in short as possible. My worry with this topic is that we observe in all our courts and the premises of our security agencies valuable assets, especially Abuja is a case in point. Valuable assets that are losing value. Houses, where we have increasing housing problem in Abuja. Houses that nobody is staying in. Cars, very expensive cars that by the time you come back, you yourself cannot drive those cars. They are just kept there without professionals. Even money. You don't just keep money in accounts. What are we doing? This is why I'm saying we need a professional agency. And I'm sorry I disagree with that's what they are doing in the UK. We have people that these assets won't just remain dormant. They will trade them. We now have, although CBN say cryptocurrency is not, we have different ways of investing these funds so that even while we are waiting for
bonds, CBN bonds and whatever.
Bonds, yes. We have ways of making these assets appreciate in value, and we need professionals that can manage assets. And I'm saying that the prosecutorial agencies are not, I'm sorry, are not cut out for that. We need professionals to manage these assets. And that is my view.
So, are we taking any other questions from? Yes, please. Can you stand up and let's identify yourself? Paul didn't need any identification, so it's not in all cases that you do identification parades.
Mr. Chairman, my Lord, panelists and fellow conferees, my name is Ruben Kinya. I am from GT Dodo and Co. My question is this. My question is directed at the lead discussant. The law abhors vacuum, and it's very clear that there's a vacuum in respect of management of forfeited assets. Do you not think that their lordships, the judges, should step in to fill that vacuum by insisting that any application for forfeiture should contain facts to show how the properties sought to be forfeited be managed, and a report to that effect be given to the court or be made to the court after a particular time? That is question number one. Question number two, there are instances where 2, 3, or a number of people put resources together to own property. And one of those people might be involved in activities, criminal activities, and proceeds from that criminal activity might be traced to the joint property. And you have said that, in OT, the Court of Appeal relied on Jonathan to say that even if the property is a jointly owned property, it can still be forfeited.
Thank you.
Are you not worried that the rights of the other joint owners of that property might be affected, since the property is not defined to the rights of the person who committed the crime, but it is the property that is the evil that is sought to be
Thank you very much. That's a very good question. Mr. Enwelum SAN himself had touched on that subject in his lead presentation, and I'm sure I'd like for him to answer that question specifically when we come to answering of questions. So I'm sure we're done with the people, gentlemen here, right? No, there's one more person from here. Yes, please, can you identify yourself and introduce yourself and then your question or remark?
Good morning. My name is Samson Egege. I'm from Didi Dodo and Co. I just want to make a brief comment regarding the topic. Now, I just want to emphasize the need to balance the interests between preservation. I'm concerned particularly with interim forfeitures, because at that stage, the rights of the owners have not been conclusively determined. And the problem we have with seizures and forfeitures does not concern only persons who have been convicted. So for interim forfeitures, for instance, the rights of persons and legal ownership hasn't been determined. These are issues that are in dispute. And we still have, we have a lot of cases where you have assets that have been confiscated or seized based on interim orders, and they are left to depreciate. So, considering, going forward, if we are looking at legislations that deal with these issues, there is a need to consider those rights and also rights of third parties, in issues of joint ownership. I think there should be provisions that allows for parties, for instance, to challenge those interim forfeitures. And also, interim forfeitures should be for a limited period of time. There should be a definite time within which the law enforcement agencies are allowed to seize properties and keep. It shouldn't be open-ended. It shouldn't be perpetual. Also, I think there should be provisions for compensation for persons, victims, whose assets have been seized, and at the end of trial, the court finds that these persons legally own these properties and they are not they are not proceeds of crime. Those persons should be compensated. There should be room for such compensation. And then finally, on the need to set up an agency that manages the assets, proceeds of crime, I think it's important to have that kind of agency. Now, Chinelo talked about the existence of agencies that can do this. But we have countries where they separate interim forfeitures and final forfeitures. And so for interim forfeitures, there are countries like Netherlands and Belgium, for instance, leave it in the hands of law enforcement agencies and court-appointed professionals. But when it comes to final forfeitures, there is a body, the Asset Management Office, which most countries have, that ensure that these assets are managed. And this is important because of accountability.
Please round up.
I'm rounding up, sorry, sir. Accountability and transparency. So in rounding off, I would say that there's a need to have that kind of agency or office so that they have defined role that ensures that they are accountable and that they have a database where they keep records of these seized assets to avoid the relooting of this asset and good management of the seized assets. Thank you, sir.
Thank you very much. Very good questions put together and very good remarks. You ate too much into our time, though, but for good cause. So, any further? All right, the gentlemen. There are some gentlemen on this side. You can't quite see them. I'm sure one or two persons may have a question. The House of Lords, right, at that end. Can we have one or two persons make a question? Please step forward so that we can see you. I came that way the last time. I think I'll want you guys to come this way this time around. So no questions from there, right? No, there is. Okay, all right. Let's take that question. At least we're ensuring that all sectors and segments are represented. Please come forward. Thank you very much. Aha, beautiful. So tell us your name and the organization you represent. Then we move on with your question.
Good morning, Mr. Chairman. My name is Muhammad Nur Idrisa. My name is Muhammad Nur Idrisa from Didi Dodo & Co. I would like to ask, what is the role of AMCON on issues of forfeiture? Do they have a role as to management of forfeited assets? Thank you, sir.
Very good question. Very good question. I'm sure the panelists here ably will answer all those questions. So, do we have any further comments or questions? Anybody online? IT. Somebody online. Yes, let's take the question. Johnson, you have a question? Ode. Okay. So Chinelo will read out the questions. So, and then tell us who the person is, and then we hear the question.
From David Stephen. He says, "Good morning, Mr. Chairman, Leonard Silks and fellow colleagues. This session is really eye-opening. Please, my question is directed at the first speaker. What is the position of the law in respect of cryptocurrencies frozen by the government prejudicially? Are there judicial remedies available to those affected? Thank you."
That's a very good question. We're in novel times, so we're in evolving times, and I'm sure our panelists Yes, thank you very much. The questions were eminently asked. Comments also were very elucidating comments, and they are eye openers, and I'm sure the panelists would aptly address the issues raised. Sorry, I didn't hear my lord say anything. I don't know if okay. Okay, my lord will give judgment on appeal. Okay, that's fine. Paul, I'm sure at some point we may need to call you, because maybe if you are talking with Leonard Silk or something, you may is following online. Okay, there may be some questions that he'd like to answer or make comments on. So we'll take our brother Emwelum SAN.
This one working now.
Mr. Chairman, I once again stand on existing protocol. The question started from the chairman of the session. He said, are there cases, new cases under company that are the direct answer is no. Then on an advance fee front, the order to be made by the judge, whether it is final or interim. Mr. Chairman, the order to be made under the Advance Fee Fraud Act is the interim, because the law itself says at any stage of the trial, and then went on to say, for such time as it may direct. It is intended to be done in the course of the trial. Perhaps witnesses are coming and it is discovered that Yes, Mr. Chairman, I was saying that the order to be made by a High Court, order of interim forfeiture, it should be interim and not final, because the law itself says the order is to be made at any stage of the trial and for such time as the court may direct. These two phrases under that section clearly show that the order is to be interim. Then on the proceeds of crime bill, I will submit, sir, that while we put pressure, as advocated by my learned brother Sale, on the legislature to pass that bill into law because of the necessity, we should also continue to advocate in courts for the conditions or the definition of the term, as I have explained in the lead paper, because the only condition is prima facie evidence produced by the prosecutor, which has been interpreted in the Jonathan's case as where the prosecuting agency is investigating or has filed charges. That is enough proof of prima facie case, contrary to the judgment of the same court in against agreement that I cited earlier on as to the definition of prima facie case. So my suggestion is that yes, we need to put pressure to get this proceed of crime bill passed in the National Assembly. Little doubt about that, no debate on that. But that we should also in court, because there's still a controversy. Some of these problems we have highlighted here today arise because of the ease with which our courts grant interim forfeiture. Was it not? I think it was yesterday's session. Somebody will say that the judiciary appears to be closer to the executive. In the grant of interim forfeiture, our courts, with all due respect, tend to believe that anybody that comes, and particularly when the charge contains some of these fabulous figures, 10 billion, 14 billion, the tendency is to believe that he did it. So the moment they say, we brought this charge, we want to seize his properties, the court will quickly grant, forgetting the definition and meaning of prima facie case determined already by the Supreme Court. If the Supreme Court goes back and all the courts if they go back to that definition which they have given, I think we will begin to make grant of interim forfeiture and order a little bit more reasonable, because it will not be easy to easily take somebody's property. Attention was drawn to where there is joint ownership of property. The same thing will happen. And so while we put pressure on the legislature to pass the proceeds of crime bill, we should also advocate strongly in courts for a better reason to be given for grant of interim forfeiture. Now, my learned friend, my learned brother Silk, that is Wole Agumbiade, asked questions on page 3, the last paragraph, whether the failure to pass the bill has solved any problem at all. And my answer is no. all those committees set up in the Attorney General's office, the like, are simply a bifurcation of the functions of one single agency. They are simply a proliferation. What I call it a committee and it's doing the work of an agency, it is the same thing. So it's a proliferation of activities that should be done by one agency. I stand and I agree with the DG Rule of Law Foundation that we need this agency, management agency, to manage it. There's this saying that when a woman marries more than one husband, she will begin to appreciate the difference between one man and the other. It is applicable in this case. We have had EFCC, Drug Law Enforcement Agency, Customs, ICPC, and so on. All of them, you recover or you get forfeiture, you keep the property in your custody. The other person gets the same thing, and so on and so on. At the end of the day, like also have been highlighted, these properties are laid to waste. But if you have one single agency, let them prosecute. In any case, it's not a duplication of duties. Prosecute. You let their job be to investigate, prosecute, identify, ask the courts to give future order, and continue with that aspect. Let some other persons, because management of these agencies do not involve lawyers alone. It has nothing to do with investigators. It has everything to do with professionals, experts in the management of properties, accountants, estate agents, and the like, to manage them. That's not the duty of investigators who are policemen and the EFCC policemen. It goes beyond the lawyers going to court to argue the case. Technical experts need to manage these properties, whether as funds in the banks or physical properties. We have had how expensive cars lie waste. Those are the things. Those are the more reason why we should have a central agency. Then question was also asked. The order of do these agencies, or do we as a nation have the capacity to trace and recover proceeds of crime from other countries? I'll talk from my own experience. Like I said, I was involved between 2002 and 2014 in the efforts to recover what is called the Abacha note. I handled the last case that the Supreme Court related to this worldwide settlement. Now, I also stated it earlier on, while we were doing that here, the federal government had its own lawyers abroad. These agencies can only collaborate with agencies abroad. When they were prosecuting Igori, I also involved in the Igori case with JBWSA. While the Nigerian prosecutors were going on here, there was a collaboration between EFCC and the security agencies in London, and there was also a Nigerian lawyer that was also involved in handling that aspect outside. It is most difficult for us or these agencies to have it here and also have it there. What they do is that they collaborate with sister agencies abroad, whom they supply this information, and of course there's a mutual legal assistance convention that has been signed between Nigeria and so many of these other countries. We use that when we were doing those cases, mutual legal assistance, which means that by the time the Office of the Attorney General, with the authority of the President, forwards that letter for mutual legal assistance, indicating areas. After your lawyers abroad have done their job, people like Enrico Monfrini in Switzerland have done their job and have identified these assets and funds, foreign banks. Then a letter will be sent under the mutual legal assistance, and the prosecuting agencies abroad will take it up, trace. When they're confirmed, they begin to prosecute, and they also engage private lawyers to assist in doing that. So my answer to that is, our prosecution agencies don't have that capacity, but they collaborate under the mutual legal assistance treaty signed between Nigeria and various countries to help in tracing and recovery of these funds. I have my problem. I have a problem with Because the way it is, my understanding of the law is that courts apply law as it is. So I have a problem with the suggestion that while granting the order of forfeiture, the court will now give an order to sell off these assets within specified time, when the law creating these agencies do not give the court such jurisdiction, and it does not bother on judicial activities because there is a lacuna. I think rather the law should be amended to take care of that. But even at that, if we have these management agencies, we won't have a need for the courts to, under the term judicial activities, begin to do what it is not authorized by law. Otherwise, the case may be taken out of appeal Supreme Court, come back and discover that this ought not to have been done. Finally, can their lordships insist that any applicant for forfeiture includes how and what time to manage the properties? I think I've answered this earlier on. Mr. Chairman, once again, I will thank everybody. I hope I've covered. Sorry, yes. I dealt with, when I in my lead paper, I dealt with the issue of the order of forfeiture, even if it is owned by the suspect and somebody who is not, an innocent owner, which is not covered. And that was the case of Uti against EFCC, which we analyzed. I want to just highlight the reasoning in that case, which says that, look, interim forfeiture is only a civil proceeding, and it is not aimed at the justice or fairness of the matter. It is the property itself that is the target, because like Justice Aka said in Patience Ibifaka Jonathan against Federal Republic of Nigeria, that the evil is the property targeted at. It's not the innocence of the suspect, but the property itself. So the interim property, which is called civil forfeiture, is only limited to the property. Hold it for the time being. That does not stop the other party from going to court with facts and documents, as done in Mike Osekume against EFCC, which I also cited, because the court made a slight departure, but not complete departure, to say where that happens, you can come to court with facts and evidence to say, look, I also own this property, for the court to make the appropriate. Finally, does ANCOM have any role? The answer is no. ANCOM operates under the ANCOM Act. It doesn't have any role to play. And I think I've answered. If I haven't, that is why I have my learned brother, Sel Jolao, to take it up. I thank you, Mr. Chairman, and I thank everybody. Good afternoon.
I think at this point I'll call on my brother Silk Jolao SAN, who will then do justice to the remainder of the questions asked.
Mr. Chairman, my lords, my colleagues, as far as I can see, all the questions raised have been answered. But I just have two comments. Now, with respect to the second speaker from the Federal High Court, who was advocating that the court should be able to go ahead to make any order with respect to what should be done with the properties. The problem is that the discretion will be very, very unlimited. And then, with all due respect to our judex, do they have the knowledge or the expertise to deal with specific kinds of property? It's not only money. There are all sorts of, somebody talked about airlines just now. There are all sorts of properties that might be purchased with the process of crime that need to be managed in a way that they will not deteriorate and that they will be useful at the end of the case. With all due respect, I suspect that the expertise to do that will not be there. And then the discretion might be too wide. For instance, EFCC is not here. But I recall that there is a case involving the late Chief of Defense, Bade, in respect of which EFCC handed over a building of his and some facilities to the Voice of Nigeria to start to use. Yeah, everybody commended that. That's actually very commendable. But the problem is that the discretion they have is too wide. It needs to be regulated by this act we are asking should be passed into law. If it's not regulated, anything can happen. This is Nigeria, we all know. Somebody's sisters, brothers, cousin might become the person who is put to manage whatever, and he might not know what to do with it. It's just to rent. Okay. Then, excuse me. Yes, with respect to AMCON's role, just in addition to what my learned brother has said, I was involved in a matter recently whereby a bank that AMCON took over, there was a suspicion that some transactions were not legit. AMCON did the proper thing by writing a petition to EFCC. EFCC now took up the criminal aspect of it. That's all, as far as we can see, with respect to existing laws they're entitled to do right now. Thank you.
Well, thank you very much, distinguished speakers. My Lord, we truly appreciate your presence. The presence of my Lord alone is a fountain of knowledge for us to merely seeing him. You know, you are learning something. And at this point, I'd like us to. Is the IT ready? IT. Are you ready and on standby? All right. So we would be joining the founder, Chief J.B. Dowd with SAN. It's our privilege hearing and learning from the founder. Dennis Silk, sir, you are welcome on board.
Hello, can you hear me?
Hey, my Lord.
Thank you. I don't know if you can hear me.
We can hear you, sir. We can hear you. Can you hear us?
We can hear you.
Yes, just one point. First of all, I most appreciate the level of intellect and industry going into this session. And it has raised a lot of profound issues. My question is just to those in charge of this session. If really that worry, very worrisome, that you have forfeited assets, interim or final listing. A few days ago, if some of you observed in the press, the whole wharf of sea ships, boats, yachts, and other floating vessels lying wait from the day they were seen with no one to manage it. And as of today, from the value of billions of dollars, they have almost nil value, because any seaworthy vessel that is not moved on the high seas and kept in sea readiness or worthiness, they will definitely go to waste. And the same thing with assets like vehicles, haulage vehicles like tankers, and other forms of mobility. Yes, I'm sure have seized an ICPC between them assets worth trillions of naira. It because they have a personal duty, a personal interest in the matter. They are carrying these things out on behalf of the people and government of Nigeria. Now we hold this kind of seminars, this kind of conferences, and raise these issues. But they are not above the law. And at one point they should be accountable. We invite them to come for these conferences, not because we want to see their faces, but we think that they have a duty to account to all. Now, when they do not show up, and these issues continue to be raised perennially, will the House be willing to give us suggestions as to how to make them accountable for this kind of lack and weight? Because the way we are carrying on in this country, honestly, it's like it goes nowhere. The corruption, and corruption is not until when you give and exchange illicit. Corruption may be in the way and manner you handle the trust or power given to you to discharge. Now, powers are placed in this agency in the hands of people who are least qualified to protect properties of that magnitude. However, political class is not to blame, because all they want to see in the pages of newspapers is that X is charged to court is property. At the level, some can stand behind the scene. Houses are let out at rent. Some are sold without the knowledge of the owners, all without following any due process or any provision of the law. So I'll be urging this and the conference to actually come up with ways in which we can make, because if we are interested in making our country a better place, and we have the courage to do so, now is the time to think of positive solutions. So that, do we compare these people by mandamus to make accounts? And that's much I may have some reservation for public interest. I am very impressed with what they do, because at times they don't people's mind and memories and act into action. So please, I'm sending it to you. Are there suggestions that you can give us? Because it is not their property, it is our collective property. And the more things go to waste, more we're impoverished. The man who stole money and bought ships and was running it employed Nigerians and other people. You come and seize them, you render all those people unemployed, and they have been specially trained. Well, that these are people, what wouldn't an alternative be to put it in receivership, allow the staff to continue with it, and begin to keep the money made in escrow? So we have a duty not only to just talk about the problem, but to offer solutions. So I took much of your time. I just felt that at this point we should come to a conclusion as to not only what the problem is, but how do we find the solution. Thank you very much.
I'd like to say we actually heard it from the horse's mouth, but that's not the horse, but that's from our leader. We heard from our leader and the convener and the founder, with over 40 to 50 years experience, active experience fighting for the cause of justice in this country. No better person can make that remark than our founder himself, Chief J.B. Dowd. Thank you very much. Please, another round of applause for. So you see, even when he is not with us here, he is still with us. We truly appreciate you. I think one of the ways to look at this matter is to ensure that once we are done with this conference, the the team, the management team, DG, will ensure that deliberations and communique from here are circulated to the managing authorities of these agencies, the Ministry of Justice, the Attorney General's Office, the DPP, the chairman, the EFCC, their director legal and their zonal heads, chairman of ICPC, the director legal and their respective heads across, so that it's something that is close by to them that they can even read on their own at their own time. And we'll continue to advocate, keep pushing until one day they will become interested and show up at this conference. For some of us, this probably is the first time we're coming here, but we can see that it is continuous. From what we learned from our sister, every year there's an update. So this is more like an update on the foundations we've had. But it is also good that we also have an idea what has been happening. We have had very wonderful time, wonderful learning experience. We've shared ideas, brilliant views have come from conferees. I think so I'd like to at this point in time appreciate very specially my Lord, yeah, listen to your paper yesterday on evidence, right? Electronic evidence. Oh yes, sorry, I hope I got online. Oh my Lord, you are most welcome. My Lord, I want to say that the body of evidence is here. Not only in an electronic form, but the real life. My Lord, you are known nationally and world over once it comes to evidence. May our good Lord continue to oil your ink. I have about 2 or 3 of your books already, but I'm just meeting. Incidentally, one of my colleagues in the office talked about you yesterday when I was watching your presentation. So it's my privilege in meeting you. Thank you. So like I said, at this point once more we'll express our profound gratitude on behalf of members of this house, my lords, the panelists, conferees. Would like to especially appreciate the founder, Rule of Law Foundation, our boss, Chief J.B. Daudu, SAN, DG Paul, and all the members of staff of J.B. Daudu and Co., as well as Rule of Law Development Foundation. We truly appreciate you. I thank you for your time. We are all leaving better informed, and we shall all continue in the advocacy. If we interact with members of the security agencies charged with this, we'll continue to share ideas with them and also encourage them to attend conferences like this and indeed the next one. I do believe that the communique will also get to them. And the advocacy with members of the legislative arm of government is also very, very important. So we shall keep at it individually and collectively. And we do hope that government one day would listen to us, hear us, and do what is necessary in the interest of our country so that we limit the wastages of our resources. Like Chief J.B. Daudu said, they are all our collective wealth. So they must be managed for the collective good of all Nigerians. So at this point, I think, having said that, I want to truly appreciate all of you and call this session to a close. All right? Call this session to a close. Call this session to a close. And then I'll ask Paul J.B. Daudu, our DG, to give a vote of thanks, and then we'll call it a day.
Please, can we give our panel a resounding round of applause? Mr. Chairman, I want to first and foremost really, really appreciate you. You went beyond the scope of your duty and even became a resource person for us. And I know that stems from your experience with the subject matter. We want to really appreciate you for joining us this year. I pray we see you many more years. And maybe next year we can have you as a panelist to give a paper on this topic, because I know you also have your own thoughts. Let's give the chairman a round of applause. To Mr. D.C. Olum, Senior Advocate of Nigeria, he's been with us throughout the inception, even from the inception of our program. And we saw his paper, we saw the approach he brought, and the resourcefulness and the elucidation throughout. Learned we are very grateful. We send our kind regards from the foundation, and we wish you safe journey back to Kaduna. Please, let's give Learned a round of applause. Mr. Gumbi Ade, Senior Advocate of Nigeria, though not here, we want to also, as a foundation, appreciate you. Your paper really stirred up, though succinct. It hit the nail on the head, and honestly, it has asked so many thought-provoking questions that we have been able to answer. And Mr. Jalawo, SCN, sir, thank you very much for taking your time to pen down your thoughts on these very, very, very important issues. Thank you very much for even giving us so much of your time. I know you have so many briefs. I'm sure you are scheduled in a court today, but you decided to just give up some of your time. And sir, this is for the service to the nation. There are several people watching this, several ministries of justice represented here. You may not know they are here and they are listening. Several states. This year we have about 6 states: Bayelsa, Kogi, Lagos, Kano, FCT, and even the police have been here. It's not all the security agencies and prosecutors. We have prosecutors here, and I'm sure they and the heads of and courts have also sent people. So these papers are reaching arms of government. But we want to also call on the EFCC and the ICPC. The ICPC were with us last year, and I think I want to just believe that it's a bit of a mix-up. But the EFCC should understand that what we are doing here is in their interest. And we have at the foundation taken our cue from the founder, and by the grace of God, we'll look at Freedom of Information Act action, especially on the issue of database of recovered assets that have been forfeited, as well as compelling them to give us certain information, and probably even acts of administrative law and take. We have taken that in from NSA, and we can do that in our private capacity. We don't have to wait for the rule of law to do that. So, in rounding up, I want to thank the entire audience and my lords, especially my Lord Honorable Justice Oredola, this year retired, and my Lord Justice Ajile. You have been with us throughout, and we appreciate you for giving us your fatherly presence here. It has given us a sense of reassurance that what we are discussing is something worth discussing. Let's give them a round of applause. So that brings an end to this session. God bless you all. But please don't go away. By 12:15, we will be starting a very interesting section. What are we talking about? We are now talking about Yahoo, cybercrime. I will be talking about international best practices in economic crime investigation and cybercrime. A lot has happened between now and last year. Hush Puppy was caught, and you know what's happened. I don't want to preempt all the issues that have come up, and the recent sanctions from the CBN on cryptocurrency and sanctions on that. So it's going to be a very interesting topic, and Latif Akbemi, SAN, will be here to chair that session, and we have various speakers, including our own Chinelo, Benedict Daudu, Chidoke Wonye. Will be here to discuss this issue of cybercrime. So please let us take a slight recess and resume back by 12:15 so that we can discuss this topic and close. Thank you very much and God bless you. So we can take a group photograph. Photographer or the resource person, let's take a group photograph.
In Nigeria's development structure, protection attention tilts towards the girl child, largely because of the natural propensity for abuse. The proclivity for sexual abuse makes the girl a weak sex. Even as the girl child receives all the attention, the importance and place of the boy child in the family and the larger society cannot diminish. The boy child in a typical lowly family is left to wallow in wants, and where his needs cannot be met, as it is in most cases, he becomes criminally impressionable. The consequence of the lack of mentorship is that the boy child is exposed to negative thoughts and vices in the community. This situation is compounded by dominance of poverty and ignorance, which make the boy child susceptible to negative peer influence and indulgences.
Girls are at risk, and sexual and gender based is on the rise in the communities, and most times perpetrators are actually boys, the boy child. So that's why one of the reasons why this project is here.
In the community, the boy is exposed to a high level of sexual abuse, rape, and gender-based violence, especially driven by abuse of dangerous substances. Such a boy child develops into an easy and pliable instrument in the hands of self-centered politicians who put him to use in electoral violence.
When people are not, or the rural populace is not guaranteed right to free education and right to also participate in political activities and governance, we must then come in and play a role. Now, one of the best ways to do this also, again, is to catch them young. We discovered that there had been I wouldn't say an undue emphasis, naturally. People get very worried when something happens to the fairer sex. I don't refer to them as the weaker sex, because in most cases, women are indeed stronger than men.
The boy child who is trapped in that situation turns round to detest school, and the consequence is that he will become prevalent in the absence of mentorship and counseling. Even while in school, albeit reluctantly, the boy child indulges in cultism, thefts, and other petty crimes. Again, this is another consequence of pure